after you have separated the facts out on your case summary, and there's a form in your book that you can use to separate the facts out or to write the facts on the right or the left, we then will apply the rules of closing. And this again is in your study materials. I want to go through several of these to comment on them. The first thing that you should do is in closing argument is to use your theory and your theme. I want to review very quickly some of the material on pages 281 to 287 regarding the creation of a theory and a theme. When you create a theory and a theme of the case, the first thing you do is to lay your cards on the table to separate out the facts that are favorable to the plaintiff and the facts that are favorable to the defense. After you have done that, then you will come up with a story, a narrative, a string of events that describe or include all of the facts. Remember that your story, first of all, should be about people. Juries are interested in people, in human beings. They're not interested in machines. They're not interested in science. They're interested in people, about people and their lives and what makes them tick, what makes them do things. Second, beyond being about people, your story should explain all of the facts. You can't leave facts out. Using our playing card analogy, it's improper and not wise for an attorney to have all the cards out on the table and then decide, you know what, I'm going to hide this card. I'm going to put this card in my pocket and I'm not going to let the jury see that card. I only want the jury to see the cards that are favorable for me, the defendant. I don't want them to see this card. This is a card favorable to the prosecution or the plaintiff. I'm simply going to put that in my pocket. That is not permissible. And your story needs to not only be about people, it needs to account for and explain all of the facts, even the bad facts. It needs to be told, your story, by credible witnesses, witnesses who are believable, witnesses that the jury reacts to. Just recently we had a jury trial right here in this room where it appeared to me as the judge that the jury was favorable towards the defendant until the defendant's client was put on the stand. The defendant, when he testified, was not credible. He was not believable. He didn't look the jury in the eye. He would tend to look around and he'd shuffle and he just was not a believable witness. And he lost the case, and I believe the defense attorney, by putting his client on as a witness, destroyed his own case because his own client was not credible. Your story needs to be supported by details. Details are what make the story come alive and be persuasive. Your story needs to make sense. It needs to be common sense. And it needs to be organized so that each succeeding fact seems more likely. Again, this gets back to the idea of the advocate or attorney being almost in the role of a writer. You need to put the facts together. You can't hide facts. You need to bring all the facts into play. But your facts need to be organized in such a way that it makes each succeeding fact or each next fact seem more likely. The next point is that in your closing, you need to argue. This is the one time in the trial when you can argue. You will learn in the next lecture, lecture 9.2, that, or actually 10.1, excuse me, regarding opening statement, that in opening statement you do not argue. You simply state what the evidence will show. But in closing argument, you are permitted to argue. You're permitted to essentially approach the jury as a human being and make your strongest arguments. By the way, let me just let me just pause here to make an observation as an old attorney and as a judge, having observed many, many hundreds of attorneys appearing in court. It is not always the most polished, the most experienced, the older attorneys that impact or are successful with juries. To the contrary, I have found that the way that an attorney presents herself or himself to the jury as a human being is the most persuasive tool you have. For that reason, I would suggest that in your work as an advocate in the future, as an attorney, as a practicing attorney, that your youth may be actually an advantage in presenting cases. The jury may relate to you, may like you, may be sympathetic to you because of your age. I would not worry, if I were you, about going up against the old attorneys. They may have more experience, they may be wiser, they may know the law better. They may have been through many, many more trials than you have. It may be your first jury trial, but you have a great advantage as long as you can connect with the jury. That is so key, that you connect with the jury. And in closing argument, that is the paramount, the great opportunity you have to connect with your jury. In closing argument, you can essentially take your gloves off and fight it out. You're not limited in presenting arguments. You may present arguments, and I would call your